All right. Hello, everyone. Welcome back. So we'll just go ahead and hurry up and get started. Our second panel will be focused on the following. Should the U.S. government actively assert its own patents? It will be moderated by Chris Morten. Chris Morten is the Deputy Director of NYU Law's Technology Law and Policy Clinic and a fellow at the Engelberg Center. Chris has previously worked at Yale Law School, where he was staff attorney and research scholar at the Collaboration for Research Integrity and Transparency, and supervising attorney and clinical lecturer at Yale Law School's Media Freedom and Information Access Clinic. Now, Chris has told me to try to be brief, but I have to say he has been an excellent resource throughout this entire event. He's been a huge brainchild for this. So thank you so much, Chris. With that, I have the honor of introducing Chris Morten in our second panel.
Thanks so much, Zach, and thanks to all the student organizers. Hope folks can hear me. If someone can give me a thumbs up. Okay, I'm seeing a nod, so great. The focus of this second panel is on a single question, which is, should the US government actively assert its own patents? The question is timely and important, I think. As Lisa mentioned at the outset of the last panel, it's a minority of drugs on which the US government holds relevant patents, but nonetheless, the US government does hold a large and important patent portfolio. For example, a report of the Government Accountability Office, the GAO, published in the fall, showed that the Department of Health and Human Services alone owns thousands of patents, and that these patents cover at least 34 different drugs approved by the FDA since 1991. I'll copy a link to that GAO report into the chat. The US government has long voluntarily licensed its patent portfolio to transfer technology out of government labs and into the private sector. But there are some recent signs that the government may become more assertive with its patents. So, for example, in November 2019, HHS and the Department of Justice brought a patent infringement lawsuit against the drug company Gilead, alleging infringement of government-owned patents on HIV prevention, HIV PrEP, and seeking potentially billions of dollars in damages. Amy Kapczynski and I had advocated that suit alongside the HIV/AIDS advocacy group PrEP for All earlier in 2019. More recently, news outlets have reported in just the past few months that the National Institutes of Health owns patents on COVID-19 vaccines, which the NIH could conceivably assert against vaccine manufacturers like Moderna to recoup public investment in vaccine R&D, or perhaps to coax vaccine manufacturers to share their know-how with the US government or with competitor manufacturers. And I'll drop a link to one of those news stories into the chat as well. So we are very lucky to have 4 eminent panelists with us today to discuss these issues. I'll provide brief summaries of their bios so that we can get into the discussion. Their full bios are linked in the event materials. Our first panelist, Barry Datlof, is the Chief of Business Development and Commercialization in the Office of Medical Technology Transfer at the U.S. Army Medical Research and Development Command. Barry has commercialized biomedical and IT technologies in the university, nonprofit, for-profit, and government sectors. He owns PregMama, a fertility company, and he has taught biotech marketing at the NIH FAES Graduate School and at Johns Hopkins. Amy Kapczynski, our second panelist, is a professor of law at Yale Law School and faculty co-director of Yale's Global Health Justice Partnership. She's also faculty co-director of the Law and Political Economy Project and co-founder of the LPE blog. Amy's areas of research include information policy, IP law, international law, and global health. Donna Meuth, our third panelist, is Associate General Counsel and lead attorney of the US Intellectual Property Department of Eisai. Donna has deep experience in IP law and pharma, chemistry, and biotech, including patent portfolio management, prosecution, and litigation. In the ABA's IP law section, Donna is currently a member of the Leadership Council, the Amicus Briefs Committee, and the editorial board for publications. Finally, our fourth panelist, Zain Rizvi, is a law and policy researcher at Public Citizen, where he focuses on pharmaceutical innovation and access to medicines. Zain has provided technical assistance to state and national governments, coordinated civil society coalitions, and published on IP, access to medicines, and global health. I've asked each panelist to begin with brief opening remarks of about 2 to 3 minutes apiece. So I'll ask Barry to kick us off, and then I'll go next to Amy, then to Donna, and finally to Zain. So Barry, the floor is yours.
Great, thank you. Just checking that my screen is shared. We're good. In the previous discussion, the model of healthcare in the US seemed to have a division between HHS and DoD. We do work on many of the same problems, but what I'd like to talk about today is a little bit of what the DoD bend is, which is to protect the warfighter and biodefense. And we have a phrase for what we do called assistive technology transfer. The goal really is to get the technology into a product. It's not about patents, it's not about royalties, it's how do we field a solution for the warfighter. A little bit of background, because I think we frequently don't think of DoD as a source of health solutions, but if you look at some of the history of just about every vaccine ever developed, had some component of DoD-ness, in part because infectious disease is a worldwide problem, which tends to, unfortunately, cross borders even easier today in airplanes. But our primary goal is biodefense and keeping the warfighter safe. We're located worldwide. We do clinical trials worldwide. We have a lot of expertise in tropical disease medicine. So things that affect other parts of the world also affect the warfighter who is stationed there and is a primary focus of some of our research. In addition to vaccines and therapeutics, which will be talked about extensively throughout today, just having a good diagnostic that works, medical devices, and increasingly the medical IT to be able to identify when, where, and how we can intervene have become increasingly important. So historically, the Tech Transfer Office at NIH, at NYU, everywhere focused on patents and licensing. We'd like to believe that there's a better way to phrase it, and that is that if our emphasis is on a product, fielding a product, then everything that happens before and after licensing is important, contributory, and something that we both can and should be involved in. And that's not always possible at all institutions. Some just do basic research, some just do applied research, some just do fielding. One of the benefits of a model of healthcare that the DoD leverages is this full life cycle capability. And we actually benefit from that because we see a need, we fill a need, but we also know exactly what we need in order to accomplish that. We talked, or some of the speakers before talked about the, in essence, valley of death. Phase 1 clinical trials in healthcare are really expenses that angel capitalists don't want to pay for. And so we have a great emphasis on trying to bridge that in collaboration with many of our economic development partners, such as Maryland TEDCO here and elsewhere in the country, other local ECDev folks. So this is critical if we're going to ask the government to step outside of basic research and actually push further towards the product side of life. We have a lot of tech transfer mechanisms. I won't belabor them today. We also have a lot of funding sources that are not traditional. People don't know about them or think about them. These are all available to us as through our website. Lastly, I'm a marketer, so I always brand because I think that it is important for everybody to be able to recognize whether that vaccine is Moderna or Pfizer, whether the source is the US government or another government. We're always looking to solidify who do you go to when you have something new and you say, is that NIAID or NCI? And so building brand is a critical element in our world. And I'll stop there, Chris.
Great, thanks, Barry. So I'll turn next to Amy for her opening remarks.
Great. Thanks so much, and really a pleasure to be here. Thanks to the student team who worked so hard to make this happen, Chris, all of you. So I wanted to talk a little bit more abstractly to start, really to speak to the question that the headline of this panel, which is, should the US government actively assert its own patents? So the first question there is, I think, what should be our goal? What should be the goal of the US government as it's thinking about managing its patent portfolio? One piece of that is product development. That's what Barry was just talking about. But there's another piece of this, which is about the government's role as the entity that exists in part to ensure that medicines are available to all of those who need them. And that particularly with something like infectious disease, that we have access to technologies as quickly as possible, right? We see that with COVID, we've seen it with hepatitis C, and we've seen it with PrEP, that particularly with infectious diseases, access now makes a huge difference because it affects the course of the disease and communication dynamics, right? So I think our goal in answering this question, what should the government do, is to speak to how the government can use its own patents to meet this broader goal: affordable access to medicines and diagnostics, vaccines, for all who need them, and especially with infectious disease as fast as possible. Okay, so what role can US patents play in this? Well, one really interesting thing about US patents, where they exist, is that they can provide leverage for the US government to work toward that goal. So if the US government holds a patent that is necessary to a technology that's in use in the world, that's been developed, there's a licensing negotiation that has to happen for that technology to be exploited. And that licensing negotiation can be an avenue for the setting out of a set of public-facing priorities, right? So if we were to talk for a moment about the COVID vaccines, right, we have some really superb results with, I'll focus on the mRNA vaccines, the Moderna and Pfizer vaccines for the moment. Pretty clear, though, that we need much more scale up of production in the US and around the world. So one could, in theory, use patents that are held by a government entity in the US, also abroad, as part of a broader negotiation to achieve those, right? To achieve those goals. And so that within that negotiation could be things about know-how transfer, things about cross-licensing, things about production targets, things about price, all of that could be folded into licensing negotiations, right? The advantage, in fact, of a licensing negotiation strategy is it's ex post. So for different diseases, different technologies, there are going to be different issues. With PrEP, for example, the pre-exposure prophylaxis for HIV, the issue there was less about supply constraints than about the price, and the fact that the price meant that we couldn't scale up to meet the needs, particularly of vulnerable communities at risk of HIV. So there, your licensing strategy would target something else, right? Than supply, for example, and know-how and tech transfer. There may be issues, think about, sort of foundational research technologies like something like CRISPR, where in fact the issue is research barriers. And so the government would want to navigate about licensing its technology in a way to ensure that research was happening in the right way. So I'll say we just have one more minute, I think. So why use patents this way? Why not instead use something like fair pricing legislation? Like, why this technique? I think we do need things like fair pricing legislation more broadly. This technique, of course, will only implicate where the government holds patents. But, we're not there yet. And so in the meantime, government patents can, in fact, play a positive role and solve real problems in the short run. The other thing is the problem isn't always price, of course, as I mentioned. So to have these ex post tailorable solutions to problems can be useful. The other thing is, I think we should talk a little bit about other strategies beyond patent negotiations, which will be coming up in the course of the day, like 1498. So I think in our discussion, government patent use provides another avenue where the government can address multiple kinds of problems. I think the other, that and the Defense Production Act can also be used. That some of those techniques, particularly Defense Production Act, are not going to be in play in the ordinary course of activities, right? Those are in play right now, but in the ordinary course of activities, if the government holds a patent, they can, in fact, still leverage that patent to say, we'd like know-how exchange, for example. Whereas, some of the other tools that we have, like the Defense Production Act, are going to be limited to sort of emergencies of the kind that we're now in. So I think of it as a very flexible tool. It's sometimes additive to other tools that are out there. But in general, additive tools can be beneficial because they can allow different players to play a role, and they can be used conjunctively to try to achieve these same goals.
Thanks, Amy. I'll turn next to Donna.
Thanks, Chris. First, thanks to NYU and to all the organizers of this conference. It looks to be an exciting and very interesting afternoon. And thank you all for including me in the program as well. Secondly, I just want to give my disclaimer that the views that I'll discuss are my own personal views and are not the views of Eisai. So in my remarks, it's in looking at the topic, should the US government actively insert its own patents, and looking at the two cases that we've identified with Gilead and also on the Moderna vaccine. I think one of the questions I have is that this is a difficult question when what it looks like from the public record is that their government had some prior partnerships with industry. So in cases such as this, for the government to assert IP relating to prior partnerships, I think that's a difficult question. And the answer to that may be tied to the facts. What was that relationship? What was the research that was done under that agreement, under that relationship? What do the terms of the agreement that govern that research state? Drug development is a long and expensive process. On an average, pharmaceutical companies spend $2.6 billion to bring a drug to market, and it takes more than a decade of work. For that investment, drug companies need to have some certainty that it can bring the product to market after putting that investment in if the product is approved. In looking at partners to work with during this long process, companies have a choice. Do we do the work ourselves? Do we hire a CRO to do the work? Or do we enter into a partnership with another company, with an academic, or with a government entity for collaborations? And these options are viewed through many lenses, both legal and scientific. On the legal side, we look at what will the terms of the agreement be. Will IP be likely? If IP is likely, who will own it? And depending upon who owns it, are there licenses in place that will protect the investment that's put into the partnership? And will those licenses be exclusive or non-exclusive? So there's a lot of legal questions that come into play as you look at how you want to do the work that will lead to a pharmaceutical product. There's also the scientific questions. Scientifically, we look at whether the investigator to partner with is a leader of the field. Can they offer some sort of expertise that we don't have in-house? What will the economics of the partnership be? Does the potential partner have something that we don't have internally? So like, for example, a particular assay or access to a certain patient population or biomarkers. So do they have something that we can't get otherwise? And then some of the questions relate to, will the partner help expedite the timeline of determine whether or not a candidate can become a drug product? So there's a lot of factors that are built into the question of, do we do partnerships, and with whom do we do those partnerships? So if, as a result of the government enforcing their IP, if that may impact how partnerships with government are looked at, does that become a risk? Is it too risky to work with the government because there's the potential that at the end of the road there will be IP asserted against us? So I think you have to look at it with that lens. Actions by the government will have consequences. Companies may not look at particular indications because they can't get access to the assays or to the patient population that they need. It may take a lot longer to get to a vaccine product in the next pandemic if there's uncertainty, and that uncertainty creates a willingness not to work with government. So I think those consequences need to be considered as we look at this question. Thank you.
Great, thanks, Donna. His opening remarks are sparking lots of questions for me, but I want to give Zain a chance to give his opening remarks, and then I'll pose a question to the panel.
Perfect, thanks, Chris. So I thought I'd just kind of give kind of a descriptive overview of where we are at. And I'll share some of the process as well, because I think it's illustrative and kind of instructive on how difficult it can be to really figure out what is going on with, US government patents and US government rights. So this is SARS-CoV-2, this is a coronavirus. And one reason it's called a coronavirus is because when you look at it under an electron microscope, you see that there's these little crowns. And the crown comes from, of course, from the spikes. And the problem with coronaviruses in general, and this is both with the latest new coronavirus, but also with previous coronaviruses like MERS and SARS, is that the spike protein is considered a good antigen. It's considered a good target. But the problem is that the spike protein is also inherently unstable. And so if you just introduced a wild type spike protein into a cell, it quickly changes shape and it goes into its post-fusion spike. And the pre-fusion spike is actually much superior for producing antibody responses. And this is something actually the NIH found out many years ago. They discovered, they invented it, they invented a way to stabilize the spike protein. So you can retain the pre-fusion spike shape even as you're introducing the protein without the rest of the virus. And so what we found was, and the process here is I was reading a scientific article by some NIH investigators on the Moderna vaccine, the NIH Moderna vaccine, sorry. And at the bottom, there was a conflict of interest, and the disclosure mentioned that there were a couple of patents involved. And to be clear, they're just still patent applications. And so, there might be a long and kind of complicated procedure before they're actually granted. But there are two patent applications. One we have more details on because it's been published. The other is still provisional, and so it's not clear what's going on. But the NIH, working with investigators at University of Texas, Austin, has essentially come up with a way of stabilizing the spike protein. And the approach basically requires substituting 2 amino acids at a critical junction in the spike protein that helps it keep that nice shape that we know from prior experiences with prior coronaviruses produces a superior immune response. And so what's interesting is that we did this analysis looking at the NIH Moderna vaccine, but it turns out this is actually quite a common technology that has been used. And so you look at the Pfizer vaccine, J&J, Novavax, CureVac, Moderna, all of them actually use the 2P mutation, which involves the two proteins I mentioned. And what's interesting here, of course, is that the NIH has done, years and years, decades of work. We calculated since the SARS epidemic in 2002, the NIH alone has spent nearly $700 million on coronavirus research and development. And so the NIH had done all this work that helped us understand coronaviruses and what appropriate antigens might be. And what makes this especially interesting is that Pfizer and J&J actually tested other antigens. They tested other proteins, and they found that the 2P proteins, the one that contained that mutation, were superior. In the Pfizer phase 2 trial, for example, the 2P protein had less side effects. And so it's what makes this, I guess, particularly noteworthy is also putting this in context, right? Like we have these amazing new vaccines that rely on government invented technology. And at the same time as all of this is going on, of course, there are also billions of dollars in public funding also going on. And so I want to contextualize kind of the patent situation because it is one part of a larger story in how the public and private sectors are working together to develop COVID-19 vaccines. So I'll stop there for now. Great,
thanks, Zain. And thanks to all the panelists for their opening remarks. I have a few prepared questions for the panel and some that are sparked by those opening remarks. But before I do anything else, I just want to encourage event attendees to submit questions of their own via the Q&A function in Zoom. We've tried to set aside some time at the end of the hour, and we'll keep an eye on your questions. So feel free to start submitting them now. So I want to spend most of our time engaging with, I think, the really deep policy considerations that Donna and Amy and Barry and Zain as well highlighted about how we should think about the place of assertion of US government-owned patents in the government's broader innovation policy toolbox alongside procurement contracts and grants and so on. But I want to start actually with what I hope is a relatively straightforward factual question that I think is important for us to get our arms around. And that's about how many commercially significant US government-owned patents on pharmaceuticals, vaccines, other medical technologies are out there. Zain obviously just presented on some analysis that he and Public Citizen have done about patents that the NIH appears to own on COVID-19 vaccines. This is a question I'll direct at Barry primarily is, as someone who works in US government tech transfer, are patents like the patents that NIH owns and patents like CDC owns on HIV PrEP, are those outliers, or are there more such patents sort of out there?
There are many more out there. It's a hard world to get this IP into the private sector without a pandemic. Just a little epidemic can even make it hard. So there are always vaccine and drug patents and patent applications that are pending, unlicensed, and at any given time. And those for all of the US government literally are hundreds to thousands of patents. When things spike, like Ebola, Zika, Corona, we do get a lot more interest, but that interest sometimes comes and goes. You've obviously seen what happened with Ebola. So the reason for technology not always being licensed right away can be that it's just too early. It's too risky. Hasn't even been peer reviewed. You know, when we switched to first to file, even government inventors had to rush and get their patent applications on file without all the data that industry would require normally for a license to be viable. And the government will continue to work on it, but now we have a pending patent application unlicensed. We also sometimes in the government have very small market sizes. Nobody cared about Ebola when it was only in Africa. As soon as it got on an airplane, people started to care about it. Zika in South America, things like that. And lastly, sometimes the IP coverage is very narrow. And it's really critical to differentiate between a composition of matter patent and a patent on just an improved way of making something or a combination, something that makes it a better product in the marketplace, maybe because it's cheaper to produce, but it's not, we created the entire cure ourselves. That happens continually because industry works with the federal government to use our labs, our BSL facilities, and to actually bring their technology into the government in order to get our technology connected to it and back out. So if we don't have foreign rights because of first to file, industry is looking at our portfolio and saying US rights only, federal government rights only, that really isn't as attractive. And we actually have a problem and a proposed solution, which I won't talk about today, that we really need to enhance the value of the portfolio of the government. But ironically, on this panel, DOJ is not sitting. DOJ is the only group within the federal system that has the right to sue for infringement. DOD doesn't, NIH doesn't. So I'll stop there.
I'll jump in quickly to say we did make an effort to get a representative DOJ on the panel, and they very graciously declined.
For the audience, Chris, it's probably worth noting, because I was able to get DOJ on one of my panels. I asked them, number of fingers or hairs left on my head, how many cases have you filed on behalf of federal laboratory patents? And it was fingers, not hair.
Right.
Not that that counts either. But it's clear that our government is not set up to litigate against industry. And I'll talk about that later. Go ahead.
Yeah, very interesting. Well, fascinating to hear that there could be many more commercially significant patents out there that the US government holds. I'm eager to let Zain and Donna and Amy react to what Barry said, but I also sort of want to open up the discussion to now bring in some of the bigger policy considerations that you all raised in your opening remarks. And I'll pose the question that sort of is a longer form of the title question of this panel, which is when or when not, and how should the US government actively assert its own patents by bringing or supporting, or perhaps just by threatening patent infringement lawsuits against drug companies? Are there occasions on which that's appropriate? Could we start to sketch a framework to guide federal policymakers as to when assertion may be appropriate or inappropriate? And I'll encourage or invite the panelists to use the example that Zain raised in his opening remarks of the patents that NIH may hold on COVID-19 vaccines, including Moderna's. Is that an appropriate case for patent assertion? I don't know if anyone wants to lead off. Amy, I see. Yeah, go ahead.
I'll jump in. So I think that the cases where, assertion should be considered is where there's a clear public benefit. And so where there's some kind of issue, lack of supply, kind of barriers to important research, or barriers to the, price barriers. So, we could sort of set out a set of criteria. It would say there's a public interest in this technology being exploited in a way that it isn't currently being. And then identify a licensing technique. Now notice what I'm doing here. I'm not imagining that the government is acting like Pfizer and managing its patent portfolio. They're not just like, is there money on the table? Let's get some of it, right? They're trying to identify where there's a public interest, because that's the position of the government, right? There's a public interest that could be met by managing its portfolio, and that's really important to appreciate. And what I would say about the very exciting work that that Zain put out there about the NIH contribution to the COVID vaccine is that does present an opportunity, where that patent does appear to be foundational to many of the manufacturing, the COVID vaccines that now have EUAs that are authorized for use. If those are not licensed, right? And one of the really interesting questions is when licensing happens. I think sometimes it happens very upstream, but increasingly what we've seen is that industry does not always have a license to government technology, even once the technology is actually out in the marketplace. And that puts them in quite a vulnerable position, right? Because they can be sued for infringement. And so I think this is an interesting example of precisely the kind of approach that we're talking about, where the government could say, and should, in my view, as part of its strategy, to say we need to scale up coronavirus vaccine production. We need a coherent plan about how to do that. How many doses do we need to meet the challenges of both American supply and boosters and all the rest of it that we're going to need, but also global, given the variants and the concerns that we have about needing to kind of start to be more ambitious about controlling the pandemic at a global scale, so that we're not doing the same thing a year from now that we're doing today. So, in that case, those patents could be used as part of a coherent strategy about the scale up of manufacturing, and part of what that would have to entail in this case would be barriers to scale up. And some of those, for example, are not patent barriers. There may be patent barriers, and so part of the story might be, let's cross-license and make sure that maybe Pfizer could produce more effectively if it had the ability to use some of Moderna's technology, something like that. There could be some cross-licensing of patents in the background, but more importantly would be the sharing of know-how, so that you would be able to turn to the companies in a position. They're not even always the companies, the headline companies, but the companies manufacturing, and build a cohort that can really manufacture these through these licensing negotiations, so that you would get Moderna, Pfizer, for example, or Johnson & Johnson to share know-how, so that you could scale up manufacturing.
Great. One thing I'll respond to really quickly is it's interesting to hear, Amy, you sort of sketch a scenario where the US government could assert its US patents in the United States, but as a kind of lever to reshape vaccine access globally, sort of like acting domestically, acting locally, but thinking more broadly, because the leverage that these patents provide could be used to renegotiate the terms of.
Right, and that really mirrors something that has been a feature of the research and policy thinking on access to medicines, which is to say the vast majority of the money in medicines markets is in the rich countries. And so if you have control over some of the rich country market, as the US, with a patent on COVID vaccines that are being sold in the US, to sort of leverage that, to enable at cost manufacture and sale in low and middle income countries, or technology transfer to low and middle income countries, so that you can sort of segment the markets. That has huge public health benefits. We don't need low and middle income markets to ensure that we get boosters for COVID vaccines. We do not need that, right? There's plenty of money in the rich country markets to get the dynamic R&D that we're going to continue to need in this vaccine space. And so we have a real opportunity here to do exactly that, sort of segment the markets, use the US rights over rich country markets, and leverage that to vaccine supply for the world.
Yeah, very interesting. I want to invite the other panelists to respond, and I might, I was going to ask Donna to think about some of the considerations that you raised, chilling effects and scaring off future public-private partnerships.
Yeah, no, and I think to feed off of what Amy said, I think the licensing part of it is important. As I said, drug companies generally are risk averse in terms of, I mean, we assume a lot of risk in the research that we do. There are many more failures than there are successes in our programs. And that's just industry-wide because of the unpredictability. But when it comes to taking a product to market, companies are not going to launch at risk, will not want to launch at risk, knowing that there's IP out there that either we can be sued upon or an injunction against us. So I think the licensing up front and early on is very important, because industry will want to reach a deal to have some certainty. So I think licensing those patents and having those relationships with industry are important. So I think that is an important part of it, because you do need certainty. You don't want to launch a product and thinking that, well, a year in, you're going to have an infringement suit against you from the US government. Nobody wants that publicity. Nobody wants that threat against you. I mean, you want to be able to develop your products, you want to be able to get them out into the market, and you don't want to have that surprise suit come up against you. Early on, when we have new projects, one of the first things we do is look at freedom to operate. So in my group, I have 2 searchers that work with me, and we'll do a prior art search, we'll do a FTO search and look at what is out there, and that may be impediments. And then we'll look at, one, is there an invalidity position against this? How strong is this IP? Do we have a non-infringement argument against it? When will the patent expire? By the time we get to market, could the IP potentially be expired? So we'll look at ways around that, and if early on in a project there is a huge risk and it's an entity that we don't think we can license, then we'll change the program. We'll have to. We don't want to take the risk of investing billions of dollars to then get to point of marketing and then having to come off the market because of an IP concern. So I think knowing that the government is going to be a partner that we can discuss licensing with is an important part of it. And I think that would go a long way to both encouraging the partnerships between us and also allowing the negotiations to happen that will result in not stopping a program, but allowing programs to go forward, but having the end result that it's a win-win for everyone.
Yeah, I want to react quickly and bring in a question from the Q&A that John Conway asked, which is, what remedy advocates for government patent assertion seek, or what remedies the government has sought in the very rare examples where it has actually asserted patents? Is the government seeking an injunction against the company who's allegedly infringing, or is the government merely seeking some kind of royalty or other money compensation? My sense of, or my knowledge of the United States versus Gilead suit is that their DOJ is seeking only monetary compensation, so there's no injunction. I'm curious, Donna and others, perhaps that squeezes some of the downside risk out from industry's perspective if their liability is, or if their exposure is maybe a payment of some amount to the U.S. government, but there's no risk of injunction.
Yeah, I mean, I guess I'd rather have that discussion on what the reasonable royalty is up front without the litigation. So not knowing the dynamics between Gilead and the government, I think for industry and for my company, it would be nice to see more of these resolutions occur pre-litigation rather than post.
Yeah, that makes sense. Yeah, and I want to pose this, kind of go back to Donna's question to Barry, and actually ask Barry what your thoughts on sort of the general effects of more frequent assertion would be, and in particular, whether you've seen any impact like that the US v. Gilead suit may have had on licensing within your group.
Sure. Assertion has been so rare that it hasn't had impact. I wish that it did, because what it would do, per Donna's comment, is really make sure that companies line up their ducks before the fact instead of running off and saying, hey, we can do anything because the US government's never going to come after us. We do like the certainty because it identifies for the government who the partner will be, or partners, because it could be non-exclusive or semi-exclusive licensing. It's not a monolithic, we only do it one way. For instance, during the pandemic, we've been doing licenses where it's really quick and easy to get a license during the pandemic, and we'll come back to the table and negotiate, particularly for things like medical devices. We're not talking $1 billion investment situation for a vaccine, but why not have licensing activities that mirror the market needs, the societal needs, and aren't just one size fits all. So we agree with our corporate partners that they would be hesitant to take a license if they knew that there was another company out there already infringing who is unanswerable, isn't going to step up and take a license particularly. And we've had that situation occur where, call it willful or just betting that the federal government will never get involved. And here we're only talking about US patents. DOJ isn't going to file overseas on behalf of a US government lab. What are we going to do about that?
Yeah, very interesting. I want to invite Zain to jump in, and maybe on to return to this sort of hypothetical around NIH and Moderna and the patents that NIH may own. Zain, I don't mean to put you on the spot, but I know that you and Public Citizen have investigated some of the contracts between the US government and Moderna and other vaccine developers. I'm curious if in those contracts you've seen anything about patent assertion, patent ownership, or there's anything that would restrict the US government's ability to assert these patents against Moderna, and also anything kind of indication of, sort of how close the decision was on the part of Moderna to take the public-private partnership offered by the US government.
Yeah, so I'd start by making kind of a less sexy theoretical point, but I think a very vital one in practical terms, which is that it is immensely difficult to figure out what is actually going on between the government and these corporations. And that's been kind of a regular feature of licensing arrangements and technology transfer, but frankly, it is a harmful feature, and it needs, I think, much more attention than it gets. It's been, what's remarkable is that the US government, of course, is the world's largest biomedical research funder, and yet it is so difficult to get details about, what patents might the US hold, what licenses has the US entered into, on what terms, are those licenses. And in general, it's been just a laborious and difficult process. And what kind of makes this, I guess, tragic in a sense is that if the US government were a small biotech, a small biotech is required to share lots of information with its investors. And so the small biotech, often posts licensing arrangements with the US government. And so you're more likely to get more detail from these small biotechs talking to the investors than you are as an American taxpayer to get from the US government. And so there's just, a kind of fundamental asymmetry, which is problematic. But that's just me ranting about not getting access to these things. The second point is, in terms of the deals themselves, so what's interesting is that Axios actually obtained some licensing arrangement between NIH and Moderna. And so to kind of clarify, what makes the Moderna vaccine, again, NIH Moderna vaccine, especially compelling is just the extent of US government involvement from its infancy. And so, it's beyond the NIH as well. So it actually starts in 2013 when DARPA, part of the DoD, invests in Moderna. And at the time, recently the head of DARPA has said, we invested in Moderna when it was 3 people. And so you can imagine, the kind of support that Moderna has gotten over the years. And so specifically on the NIH agreements, we reviewed the agreements. Some of them are publicly available, not the ones that are particular to SARS-CoV-2. And so there was what's called a research collaboration agreement. And there was work to be done on pandemic preparedness concepts. And so NIH and Moderna worked on multiple diseases, including MERS. And under the terms, which were not redacted, there was not a provision that, a license is automatically granted. So that's one interesting point. And the second point is that, so the latest patent application, the 2021, may have been, may have involved Moderna in some way. But the 2016 patent application, which was just done, by the NIH itself, actually does not have the Moderna involvement. So I think there's less of a chance there that Moderna somehow has rights in that patent unless they get some sort of license from the U.S. government. And just an update on, so what we know publicly is what we what gets reported in the media. So Public Citizen has filed FOIAs about these arrangements, of course, if there are any. The latest public update is that in August, the NIH was negotiating terms still with the companies.
Perhaps that's a good segue to a question to Donna, and that is...
Oh, Barry, can I pause you just for a second? Because
Sure.
I know that Kevin and the organizers need to do the CLE announcement.
Okay.
So a little suspense.
Go ahead, Kevin.
Thank you, Barry and Chris. So for everyone who's excited for CLEs, have I got a treat for you? The code for panel 2 will be survey, S-U-R-V-E-Y. Can use that in a sentence. One a year I took survey of IP class. So panel 2 survey is the CLE code. Again, you can find the attestation form on the pages, the events Eventbrite page and the download link under the CLE section. If there are any questions, you can email me at kq364@ny.edu. After the event, you will receive an email with a Google form for you to upload your attestation form to. So once again, the CLE code is survey, S-U-R-V-E-Y. I'll keep that up there for maybe 5 more seconds. 4, 3, 2, 1. Great. Sorry for the interruption. Chris, back to you.
Great. Thanks, Kevin. Over to you, Barry.
Zain, I appreciate hearing how difficult it actually is to get the information that you're looking for. Being a tech transfer office in the biomedical space, I will say there are ways that we could do it better, but some of the questions that are being asked do need to be appreciated by folks, and this is where I'll transition to Donna. There's only an obligation to put in the Federal Register notice if we're going to grant an exclusive license, semi-exclusive as well, any exclusivity. But if I were you, I'd be a proponent for legislation that says all federal licensing should be listed in a public place so you don't have to go through FOIAs. But my question for Donna is, would your company or other pharmaceutical companies be comfortable with other people knowing how much you paid the government up front and what the royalty is that you're going to pay for a licensed technology from the federal government? Would you wish that to be maintained as business proprietary and not FOIAble? Or would you be willing to have that publicly disclosed?
My first reaction is not to disclose. Generally, we don't want to disclose terms from any agreements because that can influence other agreements, and it's all the value of whether it's an exclusive license, how broad is the IP. So there are different factors that go into that. So I mean, my preference for my companies would be not to disclose it. Although on the flip side, it's always helpful to see what others pay because that can help with your negotiations.
So Zain, part of the solution for you is what Mark Edwards did at Recombinant Capital many years ago, which was to compile all of the royalty rates confidentially and then make some of them available in aggregate so that people actually knew about what society would have to pay for a given new technology in a given space, be it antibodies or therapeutics. The one-offs are very business sensitive because it does influence the next negotiation that NIH does or the company does. And you can't really expect somebody to open it completely up. But what I hear you saying is you need more visibility on at least who does have a license. Over?
Yeah, you'd want to know who has the license. Some technology is easier. You don't really need the exclusive license, and non-exclusive is fine. If it's broad enough technology that it would cover not only your product, but a number of products, then for those type of IP, I'm fine with a non-exclusive.
Zain, did you want to say more on that? Because I had an initial thought. Well, it reminds me of conversations we've had with universities for a long time about how public their licensing policies are. And, I think, well, it's clear why there might be private interest in keeping that information secret. I think it's less clear to me why there's public interest in keeping that information secret. I mean, one of the things that makes markets work well is when you do actually know what prices people are paying for things. In fact, the kind of canonical competitive market, like the grain market, one of the reasons it works well is everybody knows the price point, right? Because information is really critical to sort of efficient market transactions. So, I think there's ways in which we might want to set out an agenda about what's known, both for accountability purposes and even to enable markets to actually work more like we imagine they might when people have good information about price in the market. And so, but I agree entirely, that given the dynamics we're talking about, it's not going to likely happen just voluntarily. It would have to be, somebody would have to establish, it's a priority for us to make this information public for accountability reasons, and also to enable licensing that works better.
Amy, it sounds like you're at the University of Chicago. Go free market. I concur with you. I'm
talking about regulation.
I actually do appreciate having that data available as a negotiator on the government side. But I will say that there are plenty of compelling reasons on both sides. The DoD, because our emphasis is on fielding a product, very frequently will either co-fund or, in essence, cut a significant break on the license terms, because we don't care about the money, we care about the product for the warfighter. So if a company goes to NIH and says, hey, the vaccine we got from DoD was 0.5% royalty, we want the same from you, they may actually get a challenge, so to speak, in how efficient is that market, and does it matter? Is it value-based pricing, or is it impact-based pricing or cost-based pricing? And those, as you know, have been the subject of many discussions. Over.
I'll jump in and say I'm fascinated by these questions of transparency and Donna, Barry, your sort of colloquy about whether industry would accept licenses that mandated disclosure of the terms. I think it seems to me this is a clear, there's a tension between sort of the rational interests of the pharmaceutical companies entering into these partnerships and maybe us, the taxpayer, us, the public more broadly, because it seems to me that we more broadly benefit from seeing the details of these agreements. Looking back even to the first panel, as we think about various different ways to incentivize the development of new vaccines and drugs and so on, one of the, I think, really vital pieces of information we need is, what does it cost to run a clinical trial? What does it cost to fund a preclinical R&D program? And these contracts are really the best evidence that we have of that. So policymakers, legislators, all of us need access to information, I think, particularly in moments of national crisis like COVID-19. But I want to, because I know we only have 9 minutes left, I want to pose another question that I see in the Q&A, and I hope kind of ties up some of these issues. It's a question from Christian Aruchia from Prep for All, and he asks, pharmaceutical companies regularly sue one another over patent infringement. For example, ViiV Healthcare has sued Gilead over the drug Bictegravir. If we accept that as appropriate, sorry, I was reading it and then it got answered, so I've just moved to another screen, one moment. If we accept that sort of litigation as appropriate, why exceptionalize the US government? Why say that the US government should not assert its IP, especially in cases when doing so promotes a public good, like medicines access in the case of Moderna? So in some sense, I guess the question can be boiled down to is, should the government as a patent holder be viewed differently from a private company as a patent holder? And I'll try to give you each a minute or two on that question, and then we'll wrap up. Barry, see if you need to feel free to jump in.
Yes and no. we are different from business-to-business patent infringement. We actually run the patent office. Too bad they can't do us any favors for our own portfolio. But the impact of having the federal government in a lawsuit with a company is really different for investors than if another competitor is fighting it out and is normal and customary, because they don't know the extent to which the federal government will go. They do know how much a company is capitalized and how deep their pockets are for litigation, how far down the road they're willing to go. So I do think that it would benefit all for IP rights to be respected. And sadly, the only way to do that sometimes is litigation. And there may be other mechanisms that can be employed and should be employed before litigation that the federal government can use and leverage, such as what Zain was talking about in terms of CRADAs, where you have a cooperative research and development agreement, and that gives you the opportunity to negotiate thereafter for the IP rights based on law. Over.
Great, thanks. Someone else want to jump in? Amy, go ahead.
I'll jump in. I mean, I think that there is a real reason to ask government to behave differently than the private sector, because what benefits the private interests of somebody who presumptively is profit motivated and what benefits the public sector are different. And so we should ask the government, for example, not to step in. My own view is the government should not step in a market that's working, or sort of, we've got a product, everybody's got access to it. Let's say, there doesn't seem to be any price concerns, that's, and all the government doing would layer a royalty on top of it. I don't really see the argument for that. And even though it would return some money to the government, and yet that's the kind of thing that a firm would do all the time. We also see firms, engaged in patent warfare that really screws research up, right? Where, we don't have the ability to proceed on important technologies because of, and it's not something I also would like to see the government doing. So I think there are things that the private sector does that hurt the public interest, and I don't want the government to do those. So I think that's a kind of critical piece of the story. Now, that said, I think there's something else we haven't talked about in the background, which is to say, is it great for the government to run around and seek all of these kinds of patents on inventions, given that we know we have issues with patent thickets, with over patenting being a real concern with respect to giving freedom to operate for research, and sometimes also for the kind of manufacturing and dissemination of technologies. I think that it's really critical that there be a public policy of the kind we're talking about, and some transparency, that we could monitor that the government isn't actually acting just like a pharma company, because actually I think that would just increase our problems that we have, given the patent system that already has some real drawbacks.
Yeah, I mean, I think it partly is, what behavior do you want to encourage? Do you want to encourage partnership between the government and industry and researchers? And if you do want to do that, then you don't want the government suing people all the time, because that's not who you're going to look for a partner. I know in terms of industry, over the past, I guess, 5 years, one thing I've seen is that there's a lot of pre-competitive consortiums and collaborations where the companies join together, and there'll be research that benefits all the companies. And part of those consortiums is that none of the companies involved in them will file for IP. So knowing that at the start, then you're open to sharing information, you're open to exploring the mechanism of action, or what would be a potential target, or what biomarkers are important, and things that each company that's in this area can use, but without the fear that one company is going to get this broad IP that will block everyone else, or make it so that we have to license or stop our program. So I think it's partly, you see the government as being the ultimate partner that wants to encourage the advance of research, and for the companies, to solve the problems of some of the diseases that are threatening society, such as COVID, such as Alzheimer's, things that do need more than just one company and need a lot of resources. So the best way to encourage those collaborations, I think, is not to see the government as an antagonistic entity that we have to be fearful of, but as a partner that we can work with to try to solve these problems.
I think what I'll say to this is that, like, what's really needed is more policy coherence in the United States government, because the U.S. government clearly has, goals that go far beyond just getting the products onto the market, right? There are huge, especially like, let's use the COVID vaccines in context. There are huge concerns now about variants and what that might mean for both domestic vaccination, global vaccination, and kind of public health, national security, you kind of name it. And yet there is reticence on the part of many policymakers to exercise and to deploy all the tools that they have to pursue those interests and pursue those goals. And so I see patent infringement and both kind of the leverage that patents offer as just one more tool in the toolkit that the U.S. government could deploy if it wanted to address some of these incoherences. And right now we're talking about the COVID-19 vaccine context, but it's taking a step back, like the kind of central paradox in the American drug pricing landscape is that the US government is the world's largest biomedical research funder, and Americans are compensated for this world-leading investment with some of the highest drug prices in the world. And so there is a kind of, the bang for the buck is not necessarily there. And when individual tech transfer offices are narrowly construing just development as the primary goal rather than access, I think it gets us into many difficult situations that could be avoided if there was some higher level organizing structure to advance these goals.
Great. Thanks, Zain, and thank you, Donna, Barry, and Amy. I see we're out of time. I'm going to get the hook, I think, from Zach in just a moment. So let me just say, I think it's clear this question, should the U.S. government actively assert its own patents, is a very rich one for discussion. I hope to hear more on this question from all of our panelists and perhaps from some of our attendees. Personally, glad to chat more about this. I think my email is in the program. At the very least, it's Googleable. Quick round of applause for the panelists, and big thanks to all of them and to the student organizers. And I will pass the mic to Zach.
Thank you, Chris. I also wanted to thank Christian in the Q&As. I thought that was a wonderful question. And I thought that really did bring about some compelling answers for our panelists. And I want to deeply thank all the panelists here. We understand that many of you have very serious interests in this question, and these were sensitive questions. And I thought you all handled it wonderfully. And I'm honored to have you all here to sort of bring about clarity to this very important stuff. With that being said, we have 9 minutes, a 9-minute break right now until our next panel. Feel free to get up and stretch, and I'll see you all soon.